My name is Nicholas Wilson, also known as Mr. Ethical on Twitter. I blew the whistle on a massive fraud by HSBC Bank, and in the course of campaigning for recompense for the victims of the fraud, I came across the most extraordinary amount of corruption in Britain, in the regulators and Parliament and in every structure of the establishment. So I have set up a website called Corruption UK, which I will curate, and the idea is it's like citizens journalism, where people who have stories of corruption which is not likely to be reported in the media for various reasons. They don't, for example, report the HSBC fraud because of the control the banks have over the media. People can come to me with their story, and if it's all evidence and it properly stands up, I will publish the story. There are a few there already. I'm also going to be making a series of short films. The second film in the series is about the senior management and certification regime, which was brought in by the government with the idea of making senior people in the banks responsible, accountable for their misdeeds. But as you will hear, the banks have found a way around that. One of the problems I understand is the banks forging documents in court cases so they ensure that they win their case. But it's very difficult, I understand, to hold anybody at the bank responsible. Can you explain this?
This is very much the case, and this has been very carefully worked out between, I believe, the bank and the regulator in carving out the responsibility from the legal department. So in theory, you're actually giving a green light to provide fake documents, because nobody would be accountable for that under the senior manager certification regime. A perfect example is, and if whoever's watching literally looks at Broomhead versus RBS. So in theory, with the Broomhead versus RBS case, the bank destroyed him in 2018 in court. He came to myself and a team of my whistleblowers, together with my chief advisor, Steve Middleton. When we looked through all the documents that were provided in court to destroy him, we only found one genuine document. All the rest had been created and put together to destroy him. So therefore, the master was so disturbed with my statement that he refused the strikeout attempt. But it's not stopping RBS then going for another strikeout attempt, spending another £100,000 worth of taxpayer money. So in theory, you have the taxpayer bailed out RBS, and RBS are abusing the taxpayer pot.
And how many people lost their jobs?
Well, I think in that case there was about 15. And that's 15 households. And it's a knock-on of that. It's a knock-on. I would probably say that we had looked at over 70 documents and we only found one genuine document. The rest had been fabricated. And equally, the bank are not giving customers what they're entitled to under a data subject access request. There are no connection summary sheets. There's the RMP, the Relationship Manager Platform, is a very simple print screen process. But they're cutting and pasting, and they're creating Word documents, and they are cutting pieces out, sticking them on to try and create another document. It is endemic, and it is an absolute disgrace that every case really is classed as unsafe that's gone through the courts. And if they're fabricating documents in the courts, then you can be sure that they are fabricating documents in the GRG review and the IRHP review. So it's a culture that, unfortunately, and it's still going on.
It's the Wild West. I mean, there's nobody regulating.
No, not at all.
The biggest issue you face as a consumer, if you're going to bring a complaint, or if you believe somebody has forged a document, or you haven't got the correct terms, or indeed you intend to bring a claim against a bank or face a claim from a bank, the biggest issue you face is getting correct disclosure documents. And I've been involved in a number of cases that have gone through the courts where we've had earlier disclosure under data subject access requests. So we've requested the file for an individual, we've had credit submissions, credit documents from the systems, and when that case has later gone to court, the same credit submissions have hundreds of words added in that were not in the original document.
What's a credit submission?
If you're applying for, say, a commercial loan of some form, all the banks will have their own credit system. So as a business, as an SME, you say, I want to borrow £200,000 to buy my factory. They will agree terms and they will approve it with a credit team internally. So they have a system for doing this. So that system will tell the story of what you're borrowing the money for, how you intend to repay it, what your assets are, your background. So one case I dealt with, literally, we had the original data protection documents, and when we got the court disclosure, there were almost 1,900 additional words. We could actually identify where there were just small gaps in the original credit file, and they just added words of documents in there for the court disclosure.
Added to the documents you'd seen previously from the
literally extracted the genuine credit documents and typed in documents where it looked as if the manager had actually done their job properly before selling this product.
Presumably to protect themselves in the litigation.
I raised it with the lawyers on the case. The first thing they did was check the metadata, and the metadata, rather than showing 2007, as it should have done, showed 2015.
So we know it was done.
It's a huge problem. It's a problem with all of the banks. And so what happened on a case we looked at recently, there's numerous documents have gone through the court that I looked at with some whistleblowers, and we believed they were not genuine. So we went to the bank in question and said, who's responsible under the senior manager regime for disclosure? Because if you're disclosing fake documents repeatedly in court cases, the whole point of that SMCR regime is that someone's accountable. And they then pointed us to the rules, a small rule I'd not seen before, which is not in the SMCR rules, it's elsewhere in the FCA handbook. And actually, if the person who takes control of the legal function within the bank is not an approved person, so in other words, is not somebody directly authorised by the FCA, the SMCR function doesn't apply.
So this person will be a lawyer?
It's a lawyer, and effectively what they've done is carved out that responsibility from the senior management function. And when I looked at why this had happened and started questioning the FCA, it was quite shocking looking through the documents. They actually admitted in writing that some of the concerns raised were that if the lawyers who had control of the legal function were personally responsible to report wrongdoing to the FCA, if they found out about wrongdoing, they might be less likely to investigate it because of the personal responsibility. I then took that a step further with the FCA and said, well, my concern is that this might also be applying to data protection. In other words, could they separate out the data protection function? So from the start, the lawyers are controlling what is disclosed to a consumer or a business.
So they're conflicted right from the beginning of the whole
Well,
process?
the FCA came back to me, I've to and fro with them several months on it, and that they absolutely did not believe that data protection should be excluded. There should be somebody in charge of it under SMCR. So I took this back to one of the large banks I was dealing with and asked them who was in charge of SMCR in relation to data protection and data disclosure. They confirmed no one. They said that that department is controlled by group policy. So effectively, all of the disclosure you may get under a complaint system or under a claim system is controlled by the legal team, and no one is responsible to the FCA for what they produce.
So we've got this legislation which is supposed to hold people accountable, but the banks have arranged it so that the people who should be accountable are not.
Yeah, so effectively, at the last minute, when SMCR was due to come in, there was a consultation, and it was mainly the large businesses, insurance, the banks, consultants acting on their behalf, the Law Society, SRA, who got involved in the consultation. No consumers were involved, and they pushed for the legal function to be carved out of SMCR, and the FCA agreed with them. So anybody looking at the rules would not understand that. You've got to look at an intricate rule elsewhere in the FCA handbook to see how this has been carved out of responsibility. So effectively it means if you're dealing with a bank and they're repeatedly submitting forged files, fake documents, withholding key information, the FCA won't get involved because there's nobody under SMCR responsible for that.
Because it's the legal side.
Well, you know how the FCA work, Nick. So if you've got a systemic issue, It's their job to get involved. However, because that's not under their control, under a senior manager, nobody who sees this in the bank actually has a formal responsibility to report it. So effectively, let's say if I was working on a case, I notified the FCA saying, look, I'm concerned because I think they're rigging the files here, they would do their usual, oh, we don't get involved in individual cases. So both the legal teams, the banks have took responsibility on a systemic level for rigging files and falsifying documents, and the FCA have sidestepped the issue.
But why wouldn't the CEO of the bank be responsible?
Well, I've asked that question, and the answer from the FCA is, in certain circumstances, the CEO might be seen to be responsible. But obviously, if you understand how the SMCR works, in many ways it's a way of passing off responsibility from senior managers down to lower managers. Yeah, so you wouldn't even necessarily trap the CEO if the bank were found to be doing this. They design everything to make money, however they've got to do it. And when you're systemically mis-selling, well, let's face it, interest rate hedging products, 50, 60,000, fixed rate loans, 60, 70,000, PPI, hundreds of thousands, it goes on. When you're mis-selling for a living, which is what the banks do, and then number crunching to see how much compensation you've got to pay, yeah, creating systems to get around the rules is a key part of their job.
If you work in a bank and you have evidence of forgery going on, contact Bank Confidential. The details will be at the end of the film. And also, if you believe the bank have forged your signature or any documents, you can contact the Bank Signature Forgery Campaign, whose details will be at the end of the film. And of course, visit my website, corruptionuk.org.